Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, over the course of the last few months, we have had lots of stuff to geek out about, whether it's triggers, traps, magazine bans, all sorts of appellate cases going on. But the one issue that seems to get most of you really spun up is anything related to stabilizing braces. And many of you have asked, what the hell are you people going to do about it when this rule drops? Well, I have an answer for you on that. At least we're going to talk about one case that I think has the potential to completely upend all of ATF's efforts to regulate firearms with attached stabilizing braces. So, today, let's spend a few very important minutes and talk about the case that can stop ATF's overreach on pistol braces. Okay, before we get going down the road we are going down, proud to announce that this video is being brought to you by Masterworks. Listen, in these uncertain economic times when we are looking for ways to diversify our portfolio to make sure we are more adequately protected, have you ever thought about investing in fine art? Founded in 2017 by a top art collector and tech entrepreneurs, Masterworks is the platform you need to get invested in fine art. Did you know that the accounting firm of Deloitte currently values fine art worldwide at $1.7 trillion? But they're estimating that by the year 2026, that art will be worth $2.6 trillion. That's an appreciation of $900 billion over just the next 4 years. And that shouldn't surprise anybody who's been watching this for a while, because fine art has outperformed the S&P 500 by a whopping 164% since 1995. Masterworks has already sold 6 pieces of art since 2017, netting a return of 26.8% to their investors. Remember, past performance is not a guarantee to future success, but it is a good indicator. And most importantly, during times of inflation, art remains a valued investment that hedges well against inflationary prices. But most importantly, Masterworks is democratizing the art world, allowing everyone to invest in a commodity once only reserved for the uber wealthy. Listen, you don't even have to wait for the actual pieces of art to be liquidated. No, you can buy and sell your shares on a secondary market. Think about the opportunity to have an ownership interest in some of the most prized pieces of art known to man. To learn more and sign up for a consultation today, visit them at masterworks.art/Washington Gun Law. That's masterworks.art/Washington Gun Law. And let them get you invested in the world of fine art. Okay, so the case that we're talking about today is Second Amendment Foundation versus ATF, filed in the Northern District of Texas in the Dallas-Fort Worth area, brought by our favorite plaintiffs, the Second Amendment Foundation right here in Bellevue, Washington, Alan Gottlieb and all of that. Now, I've had a chance to read their pleadings, and I will tell you that this was really good lawyering at the time that the pleadings were filed. However, I have no doubt in my mind that supplemental pleadings will be filed by the Second Amendment Foundation, which is going to significantly, and I do mean significantly, strengthen this case. Now, I should also point out that, once again, Rainier Arms, a fine Washington FFL, has stuck their neck out again to be one of the named plaintiffs in this suit. So we'll put a link for Rainier Arms down below. If you guys want to show them some love, please do so. Now, as I mentioned earlier, I think the original pleadings here are really good. However, I think there has been some significant development from a case law perspective that is going to really strengthen the plaintiff's arguments here. Now, the main crux of this particular suit is twofold. Number one, a very traditional Second Amendment challenge. That is that ATF does not have the authority to regulate these, that this would be an infringement upon the person's Second Amendment rights because it regulates a type of firearm which is in common use, absolutely certain, and therefore it is prohibited. This type of regulation by ATF is prohibited under the Second Amendment. Now, a very common, normal argument that we would expect to hear. However, there's an additional argument here under the Administrative Procedures Act. Now, we're going to kind of geek out for a minute, go deep into the woods about administrative law here for a minute. But administrative law, and to Professor McCurdy at Gonzaga School of Law, thank you for this. I do remember this. Administrative law is really about one thing and one thing only, which is you are trying to sue the government to undo what the government has done or is about to do to your client. That's essentially what administrative law is. Now, there is a very particular act, the Administrative Procedures Act, which says that executive agencies must follow certain guidelines and procedures and protocols before statutes or rulemaking, I should say, before rules can be effectuated. And so one of the major challenges here is that, hey, the ATF didn't even comply with the APA, which they didn't, and they rarely do. But those were the two crux of this particular suit. Now, what the suit is claiming is, hey, listen, what we have here is a situation in which a rifle is now being redefined. Rifle, which is a statutory term defined by Congress, is now being redefined by an executive agency. And of course, they did not comply with the Administrative Procedure Act. Plus, this new broadened definition, of course, now infringes on people's Second Amendment rights. And of course, this rule would greatly affect any AR platformed or AK platform firearm with an attached stabilizing brace, what we call AR pistols, AK pistols, and would significantly also affect the ATF's new scoring criteria, which is found on ATF Form 4999, the new 4-point criteria to determine, do you have an AR pistol or do you have an SBR? And obviously, if ATF determines that you have a short barrel rifle, that firearm now is subject to either seizure, forfeiture, or taxation and federal registration. Now, as you'll recall, this rule was originally published over the summer, and there was over 211,000 comments. So kudos to all the lawful and responsible gun owners out there that responded with comments. ATF pulled the rule back and has now said that they are going to republish it in December to become effective April of 2023. Now, this suit was actually filed at a time when the first rule was published and also filed before the United States Supreme Court had issued its rulings in both Bruin and West Virginia versus EPA. So when the matter was actually filed, ATF immediately asked the court to stay the action pending publication of the final rule in December. The plaintiffs agreed to do so, and so we are waiting for the final rule, but this suit is filed, and of course, in the meantime, we have had a seismic shift, if you would, in case law. So listen, as I mentioned earlier, this suit was filed before Bruin. And so one of the many things that they were challenging is this whole two-part balancing test that all these courts were using to uphold the constitutionality of restrictive gun control measures. However, we know that the Bruin court has absolutely positively disposed of that two-part test forever, leaving us with only one part, which is, does the activity that this legislation affects, is it the type of activity traditionally protected by the Second Amendment? And if the answer is yes, it is presumed to be unconstitutional. The only time we're going to allow a gun control restriction to remain in place is if there is a long, rich tradition or a historical analog, not going back 10 years, 20 years, 30 years. I'm talking about going all the way back to the late 1700s that says these types of restrictions are the types of restrictions that were acceptable at the time that the Second Amendment was ratified. So when you take a look at what the ATF's determination and whole justification was for this pistol brace rule, it was all about preserving public safety and saving lives. It was this public interest, which is part of, well, that two-part balancing test, which has now been soundly rejected by Justice Thomas and the Bruin court. So the entire purpose for which this rule was developed, the entire reason for which members of Congress mandated ATF to go down this road, is part of an equation that is no longer considered good math. And so the entire purpose of this rule is now brought into question. But more importantly, when we take a look at a couple of cases that came out this summer, number one, Bruin. Okay, Bruin says that unless we have a historical analog, we're not going to support similar gun control legislation. Well, when we take a look at the types of restrictions that were ratified back in the late 1700s, the use of pistol braces or any regulation thereof was not an acceptable form of gun control in the late 1700s. So these types of restrictions are going to fall short on those grounds. But let us also remember that there is another case, a case that I don't think enough people are talking about, which is West Virginia versus the EPA. Because under the holdings of that case, no alphabet agency can implement rules that require or then mandate a significant shift in American commerce from one industry to another. That's considered a major question. And under the major question doctrine, that is an act that is solely reserved for Congress to allow an executive agency to implement policies that significantly shift large amounts of commerce or money from one industry to another, that's a major question doctrine. To allow an executive agency to do that is a violation of the separation of powers. Now, if we allow ATF to create all these new rules, which then subjects millions of firearms to taxation and or registration and or confiscation or surrendering, because those are the options that you're going to be left with, there is billions of dollars that is being accumulated by the United States government through taxation. That is an act that needs to be perpetuated through an act of Congress. It cannot be done through an executive agency. So the existence of Bruin and the existence of West Virginia versus EPA takes what was a very solid suit and turns it into one that is going to be razor sharp. Plaintiff's counsel correctly points out that this suit is about defendants violated and or attempted to violate the Second Amendment by subjecting plaintiffs to an unconstitutional abridgment of Second Amendment rights. By unlawfully imposing NFA registration requirements on firearms outside the APA rulemaking process, defendants have created new applications and registration requirements that unlawfully infringe on Second Amendment rights of customers of Rainier Arms, of Green and Wally, and SAF members. Listen, I think the next huge battle in our Second Amendment rights is going to take place over these pistol braces. This is a huge government overreach, and this really is the first step in what could turn out to be major gun confiscation. The case, once again, is Second Amendment Foundation versus ATF, filed in the Northern District of Texas. We're going to put a link for all of the cases and the case information down below so you can follow it, and as things develop, we will keep you posted. Listen, in the meantime, if you have any more questions about this or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.